The members of this community were referred to as untouchables or truth by the rest of the society. The British government referred to them as depressed classes. Mahatma Gandhi called them Harijans, the children of God. The Constitution of India refers to them as the scheduled castes. In a revolutionary move, the members of this community were called Dalits by Mahatma Jyotirao Phule, a politically loaded term, for it means broken, scattered. Because of the historic injustice meted out to the members of this community, they became broken and they lost their identity. French anthropologist Louis Dumont views India's caste system from the prism of purity and pollution. The dress habits, the food habits, the occupation, and the other habits of the Dalits are impure, and that of the members of the so-called upper castes are pure. That's how the mind would make a binary of purity and pollution. In the pre-colonial India, although in the colonial India as well, if there was a Dalit moving on the road and he would see an upper caste coming from the other side, he would jump in the mud because his stench will cause pollution to the member of the upper caste. As a Dalit, he had to move and he would carry a basket around his neck for him to spit inside this basket. Because if you spit on the floor, it will cause pollution to the member of the upper caste. And it was not only about untouchability, it was also about unseeable. As a member of the Dalit community, this individual had to walk. He would also carry a pole with bells so that he can alert the member of the upper caste that I'm coming, because even my shadow will cause pollution to the member of the upper castes. Such horrific atrocities have been committed against the members of the Dalit community. Dr. B.R. Ambedkar, who was himself a Dalit, faced humiliation right from the time when he was in the school. For days he could not drink water because the water from which he was allowed to drink, that turned dry. And there was water available, but that was meant for the people of the upper castes. For days he could not drink water because even Jal had Jati. And that's what Dr. B.R. Ambedkar said when he spoke of and he started Mahad Satyagraha. You might have heard of Dandi Satyagraha or the Salt March by Mahatma Gandhi when he broke the salt and went against the laws of the British government. But not many know about the Satyagraha launched by Dr. B.R. Ambedkar in 1927 when he marched towards a district, Raigad in Maharashtra, where there was a lake, Chavdar, from which the members of the Dalit community were not allowed to drink water because even this Jal had Jati. And Dr. Ambedkar addressed the people and said, it is not as if drinking water from this lake will make us immortal. We have survived well enough all these years without drinking it. We are not going to the Chavdar lake merely to drink its water. We are going to the lake to assert that we too are human beings like others. We want to preach equality. That was the Mahad Satyagraha of Dr. B.R. Ambedkar. And in fact, not many would know that a crow is considered to be the untouchable bird of India. The first food after the death is fed to the crows. These crows feed on the dead carcass of cows, of other animals. But who skins the dead animal? The members of the Dalit community. Their occupation also is considered to be impure. In fact, the dead meat of cattle was considered to be historically the only source of protein for the members of the Dalit community. And the legacy is that even today, the members of the Dalit community suffer from sickle cell anemia. That's the legacy. But then came the Constitution of India. which promised equality, which also promised justice. Justice which is social, economic, political. What sort of justice, what sort of equality does our constitution envisage? What is the version of what is this version of equality that our constitution commit us into? For that, let me give you a brief outline of equality versus justice debate. For example, here is the state, and the state is not interfering in this matter. There are three individuals who are trying to watch a match. The state is not giving anything to any of these individuals. That means the state is not interfering at all. That means what the state is practicing equality. But it does not lead to justice. It does not lead to equity. Because our constitution does not believe in the formal legal meaning of the term equality. Our constitution believes in substantive equality. And what is the substantive equality? It believes on the outcomes as well. This is where if the state interferes and removes something from this individual, gives it to the individual C, now all the three individuals are able to watch the match with utmost clarity. This is what we call equality plus justice. This is what we call equity. And this is something which has been prescribed under Article 14 of the Constitution, which talks about equal protection of the laws. Like should be treated alike. Those who are in dissimilar situation, unequal circumstances, they cannot be clubbed together. They cannot be given equality. They cannot be treated in the same fashion. So substantive equality focuses on what is the outcome of the policies and the programs of the state. The outcome here has to be that if we provide something on which this individual C will stand, he would be in a position to better watch the match with utmost clarity. This is what we call affirmative action policy. This is what we call equal protection of the law. This is what we call substantive equality, because the outcome will make it equality. And it is this equality plus justice that's at the heart, that's at the core of our constitution under Article 14 of the Constitution. But be that as it may, discrimination on the grounds of caste was rampant, rife in pre-colonial India, in the colonial India as well. After the Constitution was enacted, a remedy had to be provided. And that remedy had to be provided through law. How can we remedy these defects caused because of discrimination on the grounds of caste? For that we have Article 15, Article 16 of the Constitution. But listen to me carefully. Article 15 says, the state shall not discriminate against any citizen. Article 16 further says, there shall be equality of opportunity for all citizens. That means the focus of the Constitution is on citizens, not on groups, not on the groups of people. And why is this important? This will tell you the whole picture of the reservation system in India. And this is the only video that you need to watch in order to understand the reservation system in this country. And before we proceed, I urge you to press the like button and subscribe to our channel if you haven't yet, and share the links of these classes with your friends and fellow aspirants. Let's come to the heart of this discussion. What vision of equality does our constitution commit us into? There are two visions. One is color-blind vision of equality, and the other is group subordination theory. What is the difference between the two? According to this color-blind vision of equality, any classification on prohibited basis is suspect. What does that mean? If you classify people on the grounds of race, on the basis of the color of the skin, or if you classify people on the grounds of caste, if you classify people on the grounds of sex, if you classify people on the grounds of religion, this is suspect. This classification is not possible, is not justifiable. Why? Because if the Constitution believes in equality, if the Constitution treats all of us equally, if we are all equal and free citizens of this country, then any classification on these grounds is unconstitutional. The color-blind vision of equality, it views, listen to me carefully, it views that these terms, whether race, whether caste, whether religion, whether sex, these are irrelevant because the Constitution provides for equality, because the Constitution treats all of us equally and as free citizens of this country. And that is why the term color-blind, that means no matter what is the color of your skin, we will not classify you into different groups because the Constitution's vision of equality is color-blind. But you might ask, sir, does this color-blind vision of equality, does it basically reject or desist or abhor classification of the people? Yes, it does, but that's not the only point. So then what's the other point? The point is, for example, in 1896, an infamous judgment was given by the US Supreme Court in Plessy versus Ferguson. The point was that if we will racially segregate people on the grounds of their color of their skin, is this segregation of the people on the grounds of race, on the grounds of the color of their skin, constitutional or not? The Supreme Court said, yes, it is constitutional. But there was one judge who dissented, who disagreed, Justice Harlan. He wrote a beautiful dissent in this judgment. He said, our Constitution is colorblind. Our Constitution has to be colorblind. Because in the view of our Constitution, in the eye of the law, in this country, there is no superior class of people. There is no dominant section of the people. There is no ruling class. In our country, there is no caste. So the vision of our Constitution is colorblind. We neither know nor do we tolerate classes amongst the citizens. So our vision is colorblind. But then, at the heart of this colorblind theory is not simply that those who are the proponents of this theory, they abhor, they are distasteful towards classifying the people. No. At the heart of this colorblind theory is that citizens should be treated as individuals, not as members of groups. If we go for reservation, if we go for affirmative action policy, then it will make people stick to those groups and it will create classes in our society. It will create a society where our society is categorized and defined by those who are affiliated to and those who are the members of this group. So those who are the proponents of colorblind theory, they are not only distasteful towards classification, they say don't classify people. Why? Because if you classify people, then you are going to identify people as groups. Those who are affiliated to a group, those who are the members of this group. And ultimately, the society will be then classified into various classes. One group will control the other group, will create problems, impediments in the path of other groups. That is one idea of equality, colorblind. But then there is another idea, group-subordination theory. If there is Mr. X who has been discriminated against, who was being told that you have to carry a basket around your neck and you have to spit inside it. Why? Not because he is Mr. X, but he belongs to a group called Dalits, so-called untouchables, or truth. So people are being discriminated against, not because of their individuality, but because they belong to a group. Whether that group is on the grounds of caste, whether that group is of a woman. So individuals have been discriminated against, not because of their individuality, but because they are affiliated to, because they are the members of a particular group. And that is why substantive equality can only be achieved if we will ensure that those who have been historically wronged, those who have been historically discriminated against, they are not further subordinated. But our constitution, now that you have understood colorblind theory, you have understood the group subordination theory. Colorblind theory basically says that don't classify people, because if you classify people, then people will be identified as members of a group, as affiliated to the group, not as individuals. We need to treat people, citizens, as individuals, not as members of the group. Otherwise, there will be perpetuation of inequality. But group subordination theory, the proponents believe that people are discriminated not because of their individuality, but because they belong to a particular group. And unless and until, if our constitution really believes in substantive equality, that substantive equality cannot be achieved unless and until we ensure that this group is not further discriminated against. This group is not subordinated by another group which is dominant, which is upper caste, which is upper class. But what vision of equality does our constitution commit us to? Our constitution, it seems, it does not talk about groups. The focus of our constitution is on individuals. How? Look at Article 15, Clause 1. The state shall not discriminate against any citizen, not group. There shall be equality of opportunity for all citizens, not groups of people. So the focus of attention of our constitution is on an individual, is on the citizen, not on groups. But sir, there is Article 16, Clause 4 as well, which says, which provides an exception. What is the exception? Nothing in this article shall prevent the state from making any provision for the reservation of appointment or post in favor of any backward class of citizens. Now we are talking about a group. But those who look at the constitution, try and understand the constitution, they say Article 16, Clause 4 is only an exception. Article 16, Clause 1, Article 15, Clause 1, they focus on individuals. They don't focus on groups. So the site of constitutional action is a citizen, not the group. Because Article 16, Clause 4 is only an exception. It is not Article 16, Clause 1. And the first challenge came in the year 1951 when Madras government, it was then Madras, now it is Tamil Nadu, the government introduced a policy and provided reservation in educational institutions, in government engineering and medical colleges, and predominantly reservation was provided on the grounds of caste. Now listen to me carefully. Madras government issued an order saying there shall be reservation of seats in government engineering and medical colleges, but this reservation will be only on the grounds of caste. That means for the members belonging to SC community and ST community. Matter went to the court. The court asked Madras government, what are you trying to do? Madras government said, we are implementing Article 46 of the Constitution, which is a directive principle of state policy, which imposes a positive obligation on us because we are the state. We have to take special care. We have to promote the educational, economic interests of the weaker sections of the society, in particular SCs and STs. And we have to protect them against all forms of social injustice, all forms of exploitation. The Supreme Court in the Champakam Dorairajan case said this policy is unconstitutional. Why? On multiple grounds. Ground number one, Supreme Court said directive principles are inferior, fundamental rights are superior. If you are trying to give effect to Article 46 of the Constitution, which is part of the DPSPs, but in the process you are violating Article 15 of the Constitution, this policy is unconstitutional. But this was not the only ground on the basis of which this policy was struck down. Supreme Court said you can't make discrimination on the grounds of caste, because we believe in the color-coded vision of equality, which is we are treating citizens as individuals, not members of the group. And you cannot discriminate against any citizen only on the grounds of caste. Caste cannot be the sole determining factor for describing backwardness. Supreme Court went a step further. Supreme Court was told, but then why is there reservation for SCs and STs in employment, in government jobs, in public employment? Supreme Court said it is possible because there is an exception in the form of Article 16 Clause 4. The state shall have the power to provide reservation in appointments or posts in favor of backward classes of citizens. But a similar article, similar exception is not there in Article 15. When such a similar exception is not there in Article 15, you can't reserve seats in government engineering and medical colleges only on the grounds of caste, because then it would violate Article 15 of the Constitution. Because if Article 15 prohibits discrimination on the grounds of caste, and there is no equivalent of Article 16 Clause 4 in our Constitution, that makes this Madras government order as unconstitutional. How did the Parliament react to this? Parliament amended the Constitution, inserted Articles 15 Clause 4 to the Constitution by the first Constitutional Amendment Act 1951, which means Article 15 Clause 4 became another exception. If the Constitution says the state shall not discriminate only on the grounds of caste, but it won't apply if the state wants to make any special provision for the advancement of the backward classes of citizens, including SCs and STs. So this provision, Article 15 Clause 4, was then used by various state governments to provide reservation in educational institutions for the members belonging to SC and ST community. Without Article 15 Clause 4, this reservation could not have been provided. Why? Because Constitution is color blind. It will only look at individuals, it will not look at groups. And if it is looking at groups, it is because there is an exception provided under Article 15 Clause 4, Article 16 Clause 4. Further solidifying this color code vision of equality was another landmark judgment, M.R. Balaji versus State of Mysore, 1962. Listen to me carefully. The government in Mysore reserved 68% seats to the members belonging to socially and educationally backward classes of citizens. Why? Because Article 15 Clause 4 talks about it. Article 15 Clause 4 allows the state, which can be state government, which can be central government, that you can make special provision for the advancement of those who are socially and educationally backward, who are from the backward classes of the citizens. And when the Mysore government introduced an order and said we will reserve 68% seats to those who are socially and educationally backward, this was challenged in the court. M.R. Balaji versus State of Mysore. And Supreme Court said this policy is unconstitutional. Why? Multiple reasons. And listen to me carefully. Reason number one, Supreme Court said caste cannot be the only determinant to declare and to define those who are socially and educationally backward. If you have to identify people as socially and educationally backward, caste is not the only factor on the basis of which you can define the backwardness. This was number one. Number two, Supreme Court said Article 15 Clause 4 is an exception. Exception cannot swallow the rule. So if 15 Clause 4 is an exception, then it cannot be reservation cannot exceed 50%. So the first judgment of the court which puts a cap on the reservation up to 50% is not the Indra case. It is M.R. Balaji versus State of Mysore, 1962, wherein Supreme Court said, number one, caste is not the only factor on the basis of which you can determine whether a group is socially and educationally backward. Second, if 15 Clause 4 is an exception, then there has to be a limit on the exception. It can't be more than 50%. Reservation cannot exceed 50%. Third, and the most important thing, which will further justify our theory that Constitution originally believed in the color-coded vision of equality. Supreme Court said, Article 15's objective, listen to me carefully, Article 15's objective is to create a society where caste, as a sociological term, as a legal term, becomes irrelevant. Whose words? Supreme Court's. But how did Supreme Court come to this conclusion? How did Supreme Court say that sociologically, legally, this term caste should become irrelevant? The court was citing the speeches given by Dr. Ambedkar. Dr. Ambedkar said that this reservation should only be for a minority. When reservation should be only for the minority, that means reservation cannot be more than 50%. Otherwise, it becomes majority. It does not become minority. So, if Dr. Ambedkar had said that reservation can be only for a minority, that is why reservation cannot exceed beyond 50%. Second statement of Dr. Ambedkar, wherein he said that our reservation policy has a sunset clause. The political reservation for SCs and STs in legislative assemblies in Lok Sabha, where seats are reserved for SCs and STs in Lok Sabha and legislative assembly, it would be valid only for 10 years. After that, it will disappear. Sunset clause for reservation. The Supreme Court looked at the wordings, the speeches of Dr. Ambedkar, and said that if Dr. Ambedkar said that reservation can be only for the minority, that means reservation cannot exceed 50%. Reservation as a sunset clause, that means after 10 years it will not continue to exist, which means after 10 years this caste as a legal term, as a sociological term would become irrelevant. That means color code vision of equality, where Constitution does not look at groups, it looks at individuals. Where Constitution does not want to classify people on the grounds of race, on the grounds of caste, on the grounds of religion, on the grounds of any other criteria. Because all these terms are irrelevant. And all these terms are, Constitution is for them colorblind. This was M.R. Balaji versus State of Mysore, 1962. But now comes a shift. Till now, even the Supreme Court, and by looking at the wordings of the Constitution, we could have thought that yes, our Constitution believed in the color-coded vision of equality. Then came in 1975, State of Kerala versus N.M. Thomas. This judgment now explicitly ratifies the group subordination theory of equality, looking at individuals as members of groups rather than as individual entities. Here what happened? Kerala government provided for a provisional promotion. Provisional promotion, for example, you are provisionally admitted to an educational institute, subject to whether you have the educational qualification. We will provisionally admit you, but then when you will show your documents, you will show your certificates, then your admission will be confirmed. Should there be reservation and promotion for SCs and STs? That was the matter. Kerala government said we will provide reservation in promotion to SC community, to ST community. But for that they had to fulfill some criteria. For example, the criteria is they should have a postgraduate degree, for example. That means additional 2 years degree. Kerala government said, we will give provisional promotion to these people, members belonging to SC and ST community. That means even if right now you do not possess those educational qualifications, those additional criteria, even if you don't possess, we will promote you. But we will give you 2 grace years. Within these 2 years, you attain those qualifications. You achieve those criteria. And then your promotion will be confirmed. Matter went to the court. My lord, what is this? What? There is something called provisional promotion started by Kerala government. These people, they do not possess qualification to be promoted to a higher cadre, but they are still promoted, and in fact 2 years of grace period is given to them, that in these 2 years you fulfill that qualification, you achieve that criteria, and your promotion will be confirmed. This would clearly violate Article 16 of the Constitution, because Article 16 Clause 1 only talks about there can be no discrimination on the grounds of caste. Yes, there is an exception, but that exception is only at the time of appointment. Here we are talking about promotion. Look at Article 16 Clause 4. Nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of the backward class of citizens. Petitioner said, since it talks about appointments, it does not talk about promotion, which primarily means that this policy violates Article 16. This policy is not supported by Article 16 Clause 4 and as such is unconstitutional. But this is where, from color-coded vision of equality, Supreme Court looked at it from group subordination concept of equality. Justice A.N. Ray was the judge. He spoke of treating likes alike. Those who are in similar circumstances should be treated similarly. Those who are in dissimilar situations, different circumstances, they cannot be equated with the first group. The court said, the rule of differentiation is enacting laws differentiating between different persons or things in different circumstances. Those who are in, historically, those who have been discriminated against, members of the Dalit community, for example, socially they were discriminated against. They were not given opportunities in education as well, which means they remained socially as well as educationally backward. And over a period of time, their economic situation also stagnated, dwindled. So they were backward socially, educationally, economically as well. And such people cannot be equated with the members belonging to the upper castes, because their circumstances are different. Here circumstances are different. 4 judges, they said Article 16 Clause 4, most important point. Article 16 Clause 4 is not an exception. It is an emphatic restatement of Article 16 Clause 1. Even if there is no Article 16 Clause 4, Article 16 Clause 1 will provide for reservation. Even if there is no 16 Clause 4, Article 16 Clause 1 will provide for affirmative action policy. Because it is this Article 16 Clause 1 which permits reservation, permits preferential treatment. One judge, Justice Fazal Ali, and the other judge, Justice Krishna Iyer, who previously was a politician, who previously was a minister in the Kerala government, later on became the High Court judge and later on the Supreme Court judge. Justice Krishna Iyer, who gave the maxim that jail is an exception, bail is the norm. They are invoking Article 46 and specifically adopting the group subordination principle, saying we have to look at not individuals as individual aspects of society, but we have to look at groups, because people are being discriminated because they are part of a group, they are member of a group, they are affiliated to a group. Now the constitution is turned from colorblind theory of equality to group subordination theory. Supreme Court further said, what is the point of reservation? What is the point of affirmative action policy? It is to achieve equality between groups. Now court is reacting and reflecting on groups and not individuals. The court said, what is the site of constitutional action? It is not an individual, it is the group. Because historically injustices have been meted out to groups, and hence remedy should be provided by focusing on groups, not on individuals. But now comes the most interesting point. If the constitution talks about equality, justice, but constitution at the same time, at the heart of the constitution is affirmative action policy, reservation as a form of social justice. But how do we identify who are these backward class of citizens? Because that's what constitution refers to. The state shall reserve seats for socially and educationally backward classes of citizens. Nothing in this article shall prevent the state from taking steps for the advancement of socially and educationally backward classes of citizens. How do we identify these backward classes? For that, Kalelkar Commission was set up in 1953. And Kalelkar Commission said, we will have 6 markers to identify a backward class. This group of people, what was their traditional occupation? What was their profession? Were they doing the menial jobs, cobblers? Or were they indulging in manual scavenging? Or were they indulging in skinning the dead cows or dead animals? What is the literacy of this particular group? What is the population? What is the distribution of the population? Are they residing in far-flung areas, disconnected from the city, the mainland India? What is their position in the social hierarchy? Whether the members of this community are represented in the government service or not, whether they are represented in the industrial sphere or not. These will be the 6 markers through which we will identify the backward classes. The central government criticized these markers and said, we will not insist on this. States, you have the liberty, you decide how do you want to identify those who belong to backward classes of citizens. You decide. But right from the first amendment to the Constitution in 1951, which introduced Article 15, Clause 4, reservation was provided to SCs, STs, in educational institutions as well, in public employment as well. And the percentage was for SCs, 15% seats were reserved. For STs, 7.5% seats were reserved. But then came the question, apart from SCs and STs, there may be other backward classes as well. Apart from SCs and STs, there may be other classes, other groups who are also socially and educationally backward. That's how the Janata Party government in 1979, by a presidential order under Article 340, constituted the Mandal Commission, headed by Mr. B.P. Mandal. You identify, apart from SCs and STs, who are the other backward classes of citizens. Exhaustive survey was done, and Mandal Commission came up with 11 indicators. 11 indicators. Some were social indicators, educational indicators, economic indicators. Social indicators. Who are those castes and classes who are considered to be backward by others? 3 points to them. Caste and classes who are depending upon manual labor for their livelihood. 3 points for them. Caste and classes with low average ages of marriage, where they marry at a very young age. 3 points. Caste and classes with low proportion of female workforce, where women are not part of the workforce. 3 points. Educational criteria. Percentage of school attendance. If this is a group of people, their members, they are not attending the schools regularly. 2 points for this criteria. What is the percentage of dropouts from this community, from this group? 2 points. What is the proportion of people who have matriculated, passed the 10th standard of examination? 2 points. And then economic criteria. Value of the family assets. Look at all these people. And what is the value of family assets that they have? 1 point for family asset. Number of families living in kacha houses. 1 point. Distance of sources of drinking water. Where do they have to go to fetch drinking water? How far? 1 point for them. And those households who have taken loan, consumption loan for consumption activities, 1 point. So in total, 22 points. 4 points, 4 markers into 3 points per marker, 12 points. 3 markers, identifiers here, which means 6 points, total 18. And 1 each for these 4 points, total 22. And any class which gets 11 points is considered to be socially and educationally backward, is considered to be other backward class, other than SCs and STs. So whichever group of people, whichever caste or whichever class has 11 points out of 22, you are basically socially and educationally backward. Since you are other than SCs and STs, we will call you OBCs. But what did M.R. Balaji case say? That reservation cannot exceed 50%. Because Article 16 Clause 4 is an exception. And an exception cannot be more than 50%. That is why this commission, Mandal Commission, recommended 27% reservation for OBCs. Why 27%? So that 27 plus 15 for SCs, 7.5% for STs, total will be less than 50, which means 49.5. Mandal Commission report was submitted, it was not acted upon. Janata Party lost power. Indra Gandhi came back to power. She sat on this report, did not implement this. Indra Gandhi was assassinated. Rajiv Gandhi became the Prime Minister. Won an overwhelming majority, more than 410 seats in the Lok Sabha, did not implement this report. Then Rajiv Gandhi got embroiled in a corruption case known as Bofors, in which Amitabh Bachchan, mega superstar, was also allegedly involved. Rajiv Gandhi, as the Prime Minister, had a Defence Minister, VP Singh, Vishwanath Pratap Singh. He resigned, started an anti-corruption crusade, launched his own political outfit, and became the center of attention of all political parties. And in 1989, when elections were held, no political party got the majority. But VP Singh emerged as a dark horse, was supported by BJP on the one side, by the left parties on the other side, and VP Singh became the Prime Minister of India. But very soon VP Singh realized that I am being supported, my government is running on the support of two ideological opposites, the BJP and the left parties, the right-wing and the left-wing political party. And I may not survive for long. He said, I want to leave my legacy. And what he did, he implemented the Mandal Commission report. Massive protests in different parts of the country, particularly in Delhi University, where one student leader, Mr. Goswami, self-immolated, died later on. Massive protests in different parts of the country against the implementation of the Mandal Commission report, because reservation is an emotional issue. When the pie is being divided, ultimately these OBCs will get the benefit. This would not be taken lightly by those who will be left out of this reservation system, which means the members belonging to the general category. Series of protests. BJP was also in a fix. BJP then was considered to be a political party which was getting the support from the upper castes. Now BJP was in a fix. What do we do? Should we go for M or should we stay with M? Should we accept the Mandal Commission report or should we again start a movement for Mandir at Ayodhya? BJP withdrew support. VP Singh government fell. Elections were held. Again, no political party got the majority. Again, Congress emerged as the single largest party. And now P.V. Narasimha Rao became the Prime Minister. And P.V. Narasimha Rao said, why only Mandal? What about poor belonging to the general category? 10% seats shall be reserved for those who are from economically weaker sections of the society. That means this 50% cap has now been breached. 15% for SCs, 7.5% for STs, 27% for OBCs, 10% for weaker sections of the society, the poor, economically poor. One lady lawyer, she saw these protests, filed a public interest litigation before the Supreme Court of India. And a 9-judge bench of the Supreme Court heard this matter. And this case came to be known as the Indra Sawhney versus Union of India, the Mandal case of 1992. The question was never on SC-ST reservation because that was going on since the commencement of the Constitution. The question was on whether this OBC reservation is constitutional or not. The question was whether this 10% reservation for poor is constitutional or not. Supreme Court said Article 16, Clause 4 is enabling reservation. Article 16, Clause 4 enables reservation. It's an enabling clause because it gives power to the state that you can reserve seats. You can have reservation in appointments or posts for those who are socially and educationally backward classes of citizens. Without Article 16, Clause 4, reservation cannot be implemented. But Indra Sawhney case said reservation is not a fundamental right. Reservation is at the discretion of the state. If the state wants to provide reservation, it can. If the state does not, you can't force the state from providing reservation. But this OBC reservation is constitutional, but for that you have to satisfy 5 constitutional requirements. What are these 5 constitutional requirements? Number 1, basically you have to set up a commission so that this commission will go through the criteria and then identify those classes which are socially and educationally backward. You can't randomly pick a caste and provide them reservation. You have to show. There has to be data. There has to be a quantifiable data to prove that these classes for whom you are providing reservation, they are socially and educationally backward. This is criteria number 1. Criteria number 2, they should not be adequately represented. Now this term, adequate representation, is also a contested term. What is this adequate representation? And this term was invoked recently in the Bihar reservation case as well, which I will come to. Adequate representation may be. Till now, let's understand it this way. That if the proportion of population of a particular group is 10%, but their representation in administration is less than 1%, which means they are not adequately represented, which means there is discrimination against this group, which means they are not adequately represented. If yes, show us the data. Show us the data through which you can say that these people for whom you are providing reservation, they have to be socially and educationally backward. Then they should not be adequately represented in the administration. But then we have to introduce an element of economic criteria into it. Creamy layer. If these are the people, they may be socially and educationally backward. They may not be adequately represented in the administration as well. But within this group, there will be people who are part of the creamy layer. There will be people who are part of the non-creamy layer. Those who are part of creamy layer, they should not get reservation benefit. Those who are from non-creamy layer, they should get the reservation benefit. But who are these who are part of the non-creamy layer? For that, government will set up a criteria. For example, the criteria right now is if your father's annual income is less than 8 lakhs, you belong to non-creamy layer. If your father's annual income is less than 8 lakhs, or if your family possesses, if your household possesses less than these many acres of land, agricultural land, less than these many square feet of property in urban area. So some economic criteria is also wedded into it. This is where the creamy layer concept was introduced by the Indra case in 1992 for OBCs, not for SCs and STs, because that was not under consideration at all. Supreme Court further said, reservation shall not at any point exceed 50%. With a caveat, subject to extraordinary circumstances. If there are extraordinary circumstances, then you can breach this 50% limit. Otherwise, no. And all of this is possible subject to Article 335. Don't ever flirt with the efficiency in administration. Merit should never be compromised. That means don't make the eligibility so low that your efficiency will suffer. Don't make the educational qualification or the minimum mark so low that you will not have efficient people in the administration. Don't breed inefficiency. This OBC reservation is constitutional provided you meet 5 constitutional requirements. Set up a commission, and those castes you are including, those groups you are including, they should be socially and educationally backward. That too not adequately represented in the administration. That means concept of creamy layer should also apply. Non-creamy layer should get benefit, creamy layer should get no benefit. Reservation, subject to extraordinary circumstances, should not exceed 50%. And reservation policy once implemented, overall efficiency of administration should not be affected adversely. Supreme Court was asked, my lord, what about reservation policy announced by the P.V. Narasimha Rao government? Supreme Court said that is unconstitutional. Why? Because look at the Constitution. Article 16, Clause 4, it talks about giving protection to the state, to the people who are socially and educationally backward. Even when Article 15, Clause 4 was added, those who are socially and educationally backward. That means our Constitution does not recognize economic criteria as a basis for granting a reservation. Because reservation is not a poverty alleviation program. Reservation is to undo the historic wrongs that were perpetrated against the member of a particular group. Reservation is not a poverty alleviation program. Then, sir, how did 103rd Constitutional Amendment Act, which introduced 10% reservation for economically weaker sections of the society in 2019 when Mr. Modi was the Prime Minister. How was this made then? There is a difference. One difference is Supreme Court in Janhit Abhiyan versus Union of India in 2023 upheld this reservation policy, saying yes, it is constitutional. Why? Because there was a difference. When P.V. Narasimha Rao government introduced this policy, he announced it on the basis of a government resolution. So he passed a governmental order, and through that order, 10% seats were reserved for economically weaker sections of the society, for the poor. It was struck down. Why? Because the constitution recognizes only two kinds of backwardness: social and educational backwardness, not economic backwardness. But in 2019, Mr. Modi's government introduced a constitutional amendment bill in the parliament, amended the constitution, provided economic criteria, economic backwardness as a criteria for granting reservation. So that's the difference. 1991 order was a government resolution, was a government order. But this 10% reservation for economically weaker sections of the society, it was done by amending the constitution using Article 368. That's the difference. But be that as it may, Supreme Court here also said that reservation can only be at the time of recruitment. Reservation cannot be at the time of promotions. Once you're recruited, done. After that, you cannot take any benefit of reservation so far as promotions are concerned. This was 1992. A couple of years later, Constitution was amended again. 77th Constitutional Amendment Act 1995. Article 16(4) capital A was added, and this provided reservation in promotion for SCs and STs. Not for OBCs, but for SCs and STs. If 1992 Mandal case, Indra case, court is saying reservation can only be at the time of the entry, not at the time of the promotion. But now Constitution is amended, saying reservation and promotion for SCs and STs. Even this had to be challenged in the court. Matter went to the court, and in 2006, M. Nagaraj versus Union of India, Supreme Court upheld this constitutional amendment, saying reservation and promotion for SCs and STs is constitutional, but provide us the data, quantifiable data. Prove to us that they are socially and educationally backward. Who? Prove that SCs and STs are socially and educationally backward. But why do we have to prove it? You have to prove it because you are providing reservation and promotion. And then prove they are not adequately represented in the administration. But sir, did we not prove this in Indra case? You also said the same thing. No, that was for OBC reservation. We are talking about reservation and promotion for SCs and STs. For that, you have to prove that SCs and STs are socially and educationally backward. You have to prove that they are not adequately represented in the administration. And overall efficiency should not be affected. Even this judgment was challenged. Later on, Supreme Court said, government need not prove with data that SCs and STs are socially and educationally backward, because for that we will deem that they are backward. In a sense that you don't have to provide us data, but you have to provide us data that they are not adequately represented, and overall efficiency in administration should not be affected. This was 2006. Let's analyze this 50% cap, and then we will move to further judgments, and then come to Davinder Singh versus State of Punjab 2024. Supreme Court has said a right against arbitrariness is a fundamental right under Article 14 of the Constitution. And Article 14 has been equated to that of a basic structure, which no amendment of the Indian Constitution can violate, can delete. What is this arbitrariness? In simple terms, if I say, those who joined my class at 8 o'clock when we went live, those who joined at 8 till 8:15, whatever questions you have, I am not going to answer. But those who joined 8:15 till 8:45, I will answer all your questions. And those who joined after 8:45, I am not going to answer any single question. This decision of mine, is it with any logic? No. This is arbitrary. Instead, if I would have said that those who are from engineering background, they can ask me 10 questions. Those who are from medical background, they can also ask me 10 questions. But those who are from law background, they can ask me only one question. I am discriminating people, but this discrimination is valid. Why? Because as a law graduate, you already know all these terms. Maybe you need one or more clarifications, that's it. But those who are from the engineering background, who study one night before the exam, even then they don't. I need to be extra cautious towards you, and I can answer all your questions, whatever doubts you have. This policy is not arbitrary. There is application of mind when I make this policy. Decisions cannot be arbitrary. And the decision of the Supreme Court in this 50% cap seems to be arbitrary. Why fix this reservation at 50%? Why not 55? Why not 65? Why not 45? Why not 25? This concept 50% is arbitrary, as such violative of Article 14. But then critics also argue that reservation had to be kept at 50% because anything above 50% would make it majority. Anything less than 50% would make it minority. So reservation cannot be more than 50%. So 50% is a justifiable rule. But how did court arrive to this 50% cap? Listen to me carefully. This is the most vibrant criticism of the Supreme Court's 50% cap. Listen to me. Court arrived at this conclusion by looking at the speeches of Dr. Ambedkar. Because Dr. Ambedkar said reservation will be only for a minority, which means minority can never be more than 50%. Then it becomes majority. That is why reservation at 50%. Supreme Court said reservation at 50% cap. Why? Because Dr. Ambedkar had said that reservations will end after 10 years. Which means after 10 years, this term caste will legally and sociologically be irrelevant. That means then the color code vision of equality, where the constitution will look at individuals, not as groups. Critics argue that yes, Dr. Ambedkar was the architect of our constitution, was the chairman of the drafting committee. But a speech given by Dr. Ambedkar cannot be viewed, cannot be deemed as the authoritative statement on behalf of the entire Constituent Assembly. Even if what is attributed to Dr. Ambedkar is true, let's assume it is true. But that is his viewpoint. His viewpoint cannot be equated to the viewpoint of the collective conscience of the Constituent Assembly. If that was the case, look at Article 21 of the Constitution. The state shall not deprive an individual of his right to life and personal liberty, except according to procedure established by law. Thousands of articles on the Constituent Assembly debates would tell you that the makers of the Constitution believed in procedure established by law. not due process of law. There is sufficient literature in place where the makers of the constitution, members of the Constituent Assembly, they were aware that there is a distinction between procedure established by law and due process of law, yet they sided with procedure established by law. But what did the court say in 1978? It is not procedure established by law, it is due process of law. At that time, why did the court not go into the speeches of Dr. Ambedkar or the speeches of the members of the Constituent Assembly to say that we will not go any further, we will stick with procedure established by law? And why did in 50% case Supreme Court look at the speech of Dr. Ambedkar and said, since Dr. Ambedkar hinted at sunset clause, hinted that this reservation can be only for minority, that is why we insist on reservation at 50% cap. This, critics say, is constitutionalism of convenience. I will use the original intent when it supports my preferred conclusion and discard it when it doesn't. What is the original intent? 50%. Because it supports my conclusion, reservation should be at 50%. I will discard this original intent, even if the original intent was procedure established by law. But we are saying it is due process of law. It is nothing but constitutionalism of convenience. But be that as it may, let's look at another important judgment. Jarnail Singh versus Lachhmi, Narayan, Gupta 2018. This judgment was authored by Justice Rohinton Fali Nariman. And it was in this judgment that Supreme Court said, creamy layer within SCs and STs be excluded from the benefits of reservation and promotion. Creamy layer till now was extended only for OBCs. But now Supreme Court in 2018, in Jarnail Singh case, Supreme Court is saying reservation and promotion, if you have to provide, there provide reservation only for non-creamy layer within SCs and STs. That means now you have to segregate SCs and STs into creamy and non-creamy layer and provide reservation and promotion to those who are from non-creamy layer background. A couple of years later, Mukesh Kumar versus State of Uttarakhand 2020. The government of Uttarakhand had announced posts, advertised jobs, and said these jobs, once they are filled, there will be no reservation and promotion for SCs and STs. Now, what are you saying? I'm saying the government of Uttarakhand invited applications for government jobs, and within that notification mentioned that all these posts which are to be filled, later on there will be no reservation and promotion for SCs and STs. Mukesh Kumar challenged this in Uttarakhand High Court. Uttarakhand High Court asked the state government, give us data. What data? Show us that SCs and STs are socially and educationally forward. Why? Because if they are forward, then you don't have to provide them reservation and promotion. If they are backward, you have to provide them reservation. So give us the data. Uttarakhand government approached the Supreme Court. My lord, what is this? What? The Uttarakhand High Court is asking for data from us, but we don't want to provide reservation and promotion for SCs and STs. Supreme Court said in Mukesh Kumar versus State of Uttarakhand that Uttarakhand High Court was wrong in asking for data because reservation is not a fundamental right. If the fundamental right was snatched by Uttarakhand state, then the High Court was well within its right to ask the Uttarakhand government, give us data on what grounds are you depriving them of this fundamental right. But reservation is not a fundamental right. Reservation is at the discretion of the state. If the state does not want to provide reservation, you can't force. The crux of Mukesh Kumar judgment is reservation is not a fundamental right. If the state tomorrow does not want to provide reservation, you can't force. Then came Maratha and Bihar reservation policy. And we will link it with 50% cap. A backward class commission was set up in Maharashtra, which recommended that Marathas are socially and educationally backward, and as such should be provided reservation in government jobs and educational institutions. Matter went to Bombay High Court. Bombay High Court reduced the quantum of reservation. If it was 16%, it was reduced to 12%. And upheld the reservation. Matter went to the Supreme Court. Supreme Court said Maratha reservation is unconstitutional. Why? Because Marathas are not socially and educationally backward. One argument given by the Maharashtra Backwards Class Commission was that Marathas are socially and educationally backward because a large number of Marathis are dabbawalas, as shown in the movie Lunchbox, starring late Irfan Khan. And since they are dabbawalas, which means they are socially backward, they are educationally backward, and as such they deserve reservation. Supreme Court said, and the argument of the critics was, that the very reason why you are saying that these Marathis are, or these Marathas are predominantly dabbawalas means they are not socially backward. Because what is social backwardness? Tell them, ask this to Dalit. As a Dalit, you cannot offer cooked food to an upper caste. You cannot offer water to an upper caste because of purity pollution. If you are not making these dabbas, but you are transporting these dabbas, if you are not making this food, but you are transporting this food from their places to their places of employment, and they are collecting dabbas from you, which means you are not socially backward, otherwise they would not have accepted food from you. So Marathas are not socially and educationally backward. Bihar government launched Bihar Caste Survey. Surveyed people and classified people into backward, most backward, extremely backward, apart from those who are SCs and STs. And basis that, the Bihar government said, we have done the survey and 86% of the population in Bihar is socially and educationally backward. And for them, we are providing 65% reservation. Matter went to Patna High Court. Patna High Court said this is unconstitutional. Why? Because you are breaching 50% cap. The court was told, but this 50% gap or cap can be breached in extraordinary circumstances. Patna High Court said this is not the extraordinary circumstance. Then what is? If the survey was also conducted by the Bihar government, whether that survey was done rightly or wrongly, let's leave that point aside for a while. But the survey was done, and if 86% of the population is found to be socially and educationally backward, on that, how can the state not increase reservation beyond 50%? Otherwise, it would be a travesty of justice. I told you when we discussed adequate representation, I told you in Bihar case, I'll tell you one more thing of adequate representation. Supreme Court said, Patna High Court said, adequate representation is not the same as proximate or proportionate representation. It's not that if the population is 20% of socially and educationally backward class of citizens, 20% seats should be reserved to them. It should not be proportionate. My lord, it was not proportionate in Bihar case. If it was proportionate, then the Bihar government should have increased reservation to 86% because that is the proportion of population which is socially and educationally backward. If affirmative action policy is to correct the historic wrongs of injustice, then it would be injustice if we correct these wrongs only for some sections of the society and leave the rest. If 86% is vulnerable, if 86% they are socially and educationally backward, we have to provide benefit to all of them. We can't pick and choose and say only 50% of them will get reservation. That would be the travesty. So in some cases, even with data at hand, the court is not accepting that data. For example, in Bihar case, the data was there in the form of Bihar caste survey, which proved that 86% population was backward. Even then you insist on 50% cap. This is another criticism of the 50% cap imposed by the court, first in Balaji and then in Indra or Mandal case. Now comes the point. State of Punjab versus Davinder Singh, 2024. The year was 1975 when Punjab government issued a notification saying when we will provide reservation for SCs, there we will give precedence to Balmikis and Mazhabi Sikhs, two of the most backward communities in Punjab. That means what are you trying to do? You are sub-classifying SCs. Balmikis and Mazhabi Sikhs, they belong to the SC community. But so are other SC community members. But now Punjab government is issuing an order that when it comes to priority, we will first prioritize reservation for these two, the most backward of the SC communities, Mazhabis and Balmikis. This notification was challenged Why? Because there was a 2004 judgment given by the Honorable Supreme Court in a case known as E.V. Chinnaya versus State of Andhra. Because a similar law was passed in Andhra, which prioritized some SC groups from getting SC reservation. That means sub-classification. Supreme Court said, a 5-judge bench of the Supreme Court in E.V. Chinnaya versus State of Andhra Pradesh in 2004 that this is unconstitutional because states cannot tinker with the SC ST list. States cannot sub-classify SCs, sub-classify STs. And what is this sub-classification? Listen to me carefully. If there is a group SC and there are castes X, Y, Z, P, Q, R, 15% reservation is for SCs and that is for the entire group. Can we sub-classify saying since R is more backward than others, we will give them 4%. Then Q is more backward, we'll give them 3%. Then Y is more backward, we will give them 2%. And the rest will be distributed. This is what we call sub-classification. Punjab government through this notification is doing exactly this, sub-classifying. And same was done by Andhra Pradesh, by a law passed in Andhra Pradesh, which in 2004, 5-judge bench of the Supreme Court said is unconstitutional. And when it came to light in 2004, this Punjab notification was also challenged. And in 2006, the Punjab and Haryana High Court said this notification is unconstitutional. Why? Because on the grounds of the judgment given by the court in 2004. by the Supreme Court in 2004 in the Chinaya case. The very year 2006, Punjab legislature enacted a law. Now forget about notification, we will enact a law and we will still prioritize the Balmikis and the Mazhabi Sikhs. This law was further challenged in Punjab and Haryana High Court, and in 2010, Punjab and Haryana High Court said this is unconstitutional. Who challenged this? Davinder Singh. He was not from the Balmiki, he was not from the Mazhabi Sikh community. He was the one who would have been affected, challenged it, and Punjab and Haryana High Court in 2010 said it is unconstitutional. And then the matter reached on an appeal before the court. Supreme Court said maybe we need to revisit the Chinaya judgment. Since Chinaya judgment was given by 5 judges of the Supreme Court, we will have to set up a 7-judge bench of the Supreme Court. And a 7-judge bench of the Supreme Court was set up. And now the 7-judge bench of the Supreme Court in August 2024 ruled something. And what did they rule? For that we need to understand Article 341 of the Constitution. Why this is important? Because this is the only definition of SC provided in the Constitution. SC ST. Bill will be passed by the Parliament if a caste is to be added to the scheduled caste list or removed, if a tribe is to be added to the scheduled tribe list or removed, for that bill has to be passed by the Parliament by simple majority. And then once this bill is passed by the Parliament, the President will notify. What the President will notify? Constitution Order of 1950. And it is this Constitution Order of 1950 which will have the list of all the SCs, of all the STs. According to Article 341. Because what the President may do with respect to any state or any union territory, or if it's a state, after consultation with the governor of that state, and will specify that these are the castes which are SCs, these are the castes which are STs. This list. Who has this power? Parliament. Who has this power to notify this list? President, which means the central government. Do state governments have any role here? No. And that is why you can link it with what is happening in Manipur right now. In Manipur, Metis. Some of the Metis were SCs, some of the Metis were OBCs. But they had a long pending demand that we should be classified as STs, scheduled tribes. Went to Manipur High Court. Manipur High Court issued an order directing the state government that within 1 month of the receipt of this order, you have to consider granting ST status to Metis. And this triggered the clash between Metis and Kukis in Manipur, and Manipur is still in turmoil. Manipur High Court order was later revoked, recalled. Why? Because it was against the Supreme Court judgment in Milind versus State of Maharashtra of the year 2000, where a 5-judge constitution bench of the Supreme Court said that no state government, no court, no tribunal has the power to add something to SC list or delete something to SC ST list. This power is only with the center, which means Parliament will enact a law, and basis that law, the President will notify the SC list, the ST list. So who has this power? This power is with the Parliament. This power is with the President. To add something to this list, to remove something from this list. And it was this basis that was used by the court in Chinmaya case, wherein it said if this is the power with the parliament, states cannot subclassify SCs. Because if this SC list is given by the center, if the states are allowed to subclassify like this, it will go against Article 341. As such, it is unconstitutional. States cannot subclassify SCs and STs. But in the state of Punjab versus Davinder, Supreme Court said 7 judges of the Supreme Court heard this matter. There was only one dissenting judge, Justice Trivedi. The remaining 6 judges, they said this subclassification of scheduled castes or scheduled tribes is valid. And who can do that? States can do. And basically this court reversed this 2004 E.V. Chinnaya versus State of Andhra Pradesh judgment, which had said that subclassification of scheduled castes is impermissible. But there were 4 issues that the court had to hear. Issue number 1. Are all castes in the SC list to be treated similarly? Listen to me carefully. Slightly technical, but I will try and make it as simple as possible for you to understand. There is something called legal fiction. Something which does not exist, fiction, but is considered to be legal according to the law. Or should we say something which doesn't exist, but exists for the purpose of the law, exists for the courts, exists for the law. Scheduled caste, scheduled tribe is a legal fiction. Such an entity does not exist. There are various castes which form SC community, various tribes which form ST community. So there are tribes, there are castes, but there is no such thing as scheduled caste or scheduled tribe. It's a legal fiction. And the argument was that all these castes in the SC list, all these tribes in the ST list, they are homogeneous. There is no difference between one and the other caste, one and the other tribe. They are all homogeneous. And when they are homogeneous, further classifying a homogeneous entity would be unconstitutional, unpermissible, because it will violate Article 14. Because then it would be arbitrary. Because if a group is homogeneous and you are further subclassifying it without any logic, it is arbitrary. As such, violates Article 14. That was the position of the court in the Chinnaya case, where court said these SCs and STs, these are homogeneous. This group is homogeneous. Further subclassification is not possible. Supreme Court in Davinder Singh case said, we understand this legal fiction, that there is scheduled castes, scheduled tribes, but this concept of legal fiction cannot be further extended to say that these castes are homogeneous and cannot be further subclassified into various subclasses. No, we can't do that. So subclassification is allowed because these castes are not homogeneous. Some castes would have faced more degree of discrimination than others, would have faced more number of years of discrimination as against others. These castes in SC list, they are not homogeneous. When they are not homogeneous, that means they are not to be treated similarly. When they are not to be treated similarly, which means they can be subclassified. When they can be subclassified, but now the question is, who can subclassify? States. Who are these states? Article 12. Article 12 talks about the definition of the state. The state shall not do this, the state shall not do that, the state shall not discriminate, the state shall provide equality. Who is the state? Definition of the state is under Article 12. The central government, the state government as well, it's also included in state. So states can subclassify this presidential list. Justice Gawai, and I'll tell you the argument of Justice Gawai slightly later as well. Justice Gawai, who was one judge on the bench, he said, look at those who are opposing this subclassification. They are similar to those people who were not allowed to enter the general compartment of a train. But once they got entry into the general compartment of the train, now they are using all tricks and trades to prevent others from entering this compartment. This we will not allow. Third, what is the yardstick for such subclassification? That when the states will implement this subclassification, it has to be reasonable, and we will see, because we have the power of judicial review, whether that classification, subclassification was done reasonably or was it arbitrary. So the big takeaway from this judgment is subclassification of SCs and STs permissible? Yes. Who has the power to do that? States as well. Now comes the last important point, the most often misunderstood aspect of this judgment. Does the creamy layer principle apply to scheduled castes? The simple answer is no. Yes. There were 4 judges. Justice Gawai was the author, who said that it should be applicable. Creamy layer should be made applicable to SCs as well. But that was not part of the judgment. That was obiter dicta. The observations made by the court, which are not part of the judgment, which means it is not binding on the state, which means it's not binding on the government to provide creamy layer principle and make it applicable to the SCs. That is not possible. That is not necessary. But can this government do this? Yes. And the government can still say, although it will be politically suicidal for any government to do this, but if the government does this, it can say that it is on the orders of the court because it was part of the obiter dicta. But it was not part of the main judgment. In fact, Justice Chandrachud, the Chief Justice of India, does not even address this aspect. 4 judges, Justice Gawai's judgment. It does mention that this concept of creamy layer should apply to SCs, but that is only an observation. It is not binding on the government. This was Davinder Singh versus State of Punjab judgment. Now the point is this judgment good, bad, or ugly? SCs and SCs, SCs and STs, let's accept and agree, they're not homogeneous. There are select group of castes which are taking more benefit as against the others. And for real substantive equality to happen in the society, this subclassification is necessary and a welcome step. But how this subclassification is to be done, that is important. For that we need data. How do we get the data from caste census, which is not happening? How do we get this data from census, which is not happening? Census 21 has not been conducted. Criticism of this judgment is, in Bihar case, where the Bihar government said we should provide 65% reservation to socially and educationally backward class of citizens. Supreme Court said not possible. Patna High Court said not possible. Matter went to the Supreme Court. Supreme Court did not impose a stay on this judgment. Supreme Court said we will hear. Despite data staring at your face, you are still saying that it is not an extraordinary circumstance to breach 50% cap. In SC ST Davinder Singh case, there is no data which points out to the court that sub-classification is necessary because some castes are taking more benefit as against other castes. Some tribes are taking more benefit as against other tribes. There is no data. We need data. Then we need a judgment. If this creamy layer concept is applied, do you know what will happen? A large number of seats will remain unfilled, vacant. Why? Because we won't get the candidates who meet these requirements. Even today, there are a large number of seats. Forget about UPSC, in other areas. Large number of seats which are remaining vacant. Why? Because we don't get suitable candidates from the reserved categories. And further, if you impose creamy layer, then further seats will remain vacant. There is political angle to this as well. SCs were viewed as one group. Together they had a voice. If this creamy layer concept is applied, then this SC group will further dismantle into smaller groups and they will lose their collective voice. And is this sub-classification or a creamy layer concept a red herring? Red herring in a sense, a distraction, where the real focus should have been on the objective of the Constitution, which is Article 17. Untouchability is abolished and its practice in any form is forbidden. Untouchability is still rampant. Critics say this judgment is a red herring, distraction. We are being distracted into these issues of creamy layer or sub-classification, whereas the real issue is the caste atrocities that are still rampant in India. That's why, look at this slide. The representation of scheduled castes and tribes in services and states have not yet reached the required level. Economic criteria and creamy layer could affect the availability of candidates and could further increase the number of unfilled jobs in Indian institutes of technology, IIMs, universities and scientific institutions. Because even now, the posts are vacant in many institutes due to discrimination. There are other backward classes. It is easy to classify other backward classes into creamy layer and non-creamy layer. Why? Because they have access to property, land. Most of the Dalit communities have no such assets on which they can be evaluated upon. Sub-classification might open a Pandora's box of issues. In the absence of 2021 census data, the current population strength of the subcaste needs to be ascertained first through enumeration. This would mean caste census. Then we have to look at, after we have enumerated, what is their adequate representation in the administration. It's a long drawn process. At the cusp of 75 years since Constitution came into force, as we look back, we are still far from one of the primary mandates of the Constitution, which is the abolition of untouchability. This was the judgment of the court in Davinder Singh versus State of Punjab 2024, where Supreme Court said sub-classification of SCs and STs is permissible. Who can sub-classify? States as well. But that sub-classification has to be reasonable. It cannot be arbitrary. But has the court mandated that creamy layer shall apply to the members of the SC and ST community? No. It is part of the observation. It is part of obiter dicta. As such, it is not binding on the government. Whether the government will come up with something and overturn this judgment, we have to wait and watch. Because in 2018, the Supreme Court had diluted the effects of the Atrocities Act of 1989 by mandating a preliminary inquiry into the atrocities, by mandating that there should be no automatic arrest and FIR unless and until the permission is given by the Deputy Superintendent of Police or SP, no arrest can be made. These provisions were meant to dilute the Atrocities Act of 1989. Series of protests in different parts of the country, and ultimately the government succumbed to the pressure, amended the Atrocities Act, and restored status quo ante. Wherein, what was the position of this law prior to the judgment, Subhash Mahajan judgment of 2018? The same position was restored. That means now automatic arrest upon the registration of the FIR, no need for a preliminary inquiry, no need for the written permission of the DSP or the SP to make arrests, and no bail to those who are accused of committing atrocities. This was the position of the law prior to 2018 judgment, and now this provision has been, this status has been restored. That is after the outcry, after the protests. And we saw the Bharat Bandh protest recently on this judgment. So whether the government will be able to uphold this judgment, in a sense allow states to subclassify, or maybe they will enact a law to dilute this judgment, that remains to be seen. And if you have understood all the topics that we discussed today, do let me know in the comment section. Do not forget to press the like button and subscribe to our channel if you haven't yet. And let us know if there are further topics on which you want a nuanced explanation or understanding of these topics. Thank you for staying with me on Friday evening. Good night. Goodbye.